executive session?
I won't be going out door. I stay in
Can we move to the next item?
Yeah, well, there's other old business.
All of the items under old business will require unanimous vote by the board.
Okay. So you don't have one.
We don't have it?
Wait, well, you mean unanimous of members present? In other words, you need a supermajority, is that what you
That
mean?
is correct. Each one of the items under old business.
You don't need 5, you need 4 votes.
Correct, but there are only 4 members present,
Right,
so they would need to be unanimous.
Yeah, I think Ms. Patrick thought you meant all 5 members.
Ms. Patrick is, I'm sure, able to say whatever it is she thinks I meant to tell me directly. She's never hesitated before. But on each of those items, if each of those items is to be approved, it will require overrides of various elements of the GMF on each of the items of old business.
And these 4 items are already built?
Yes, so I would note, just to put it into a bit of perspective, to introduce it to members of the board. 3 of these are already built houses, and the other one already has foundation and framing. So why are we here? Moreover, all of these already had variances approved by the Zoning Board of Appeals prior to their construction, so why are we here? We're here because at the time that these matters were heard by the Zoning Board, year, 2, 3 years, it was not the practice of the Village of Spring Valley to send out requests for general municipal law review, pursuant to Section 239 of General Municipal Law, which the village should have been doing. When individuals then went to other county agencies for permits, in some cases post-construction, they were told, oh, show us that you complied with general municipal law review. But there was no general municipal law review, not because the applicant didn't seek a general municipal law review, but the village and its operations was not being attentive to that particular element of the process. I'm putting aside the legal issues of whether the county can now go properly all these years later, say the Village of Spring Valley didn't send us a letter to comment on something, and now we don't know how the board would have reacted if they knew what our comments were in 2016, and would they have granted permission. So now we're going to issue in 2018 a letter to this board which didn't consider the original application, so that we can find out what the board that did consider the application might have done. So I happen to find it somewhat absurd from a procedural point of view, but we want everybody to be happy, and even though these are reopening old matters and buildings that are already constructed, and frankly, it's my point of view that, from my point of view, once these buildings were permitted, everything else, permits issued under apparent authority, relied on by applicants to the tunes of millions of dollars once you start to spread across all these properties. I believe that any applicant that would be thereafter denied for variances that had previously been granted merely because of this would have claims against the village for all of that, insofar as it's the obligation of the municipality to circulate the general municipal law review to begin with. That said, what we have prepared for the record on each one of these applications is a statement of those elements of the general municipal law which are incompatible with the project as approved. So there's the board applied the balancing test each time it approved these projects and found that it would not have an adverse impact on community character. The fact that the county then comes and says this may have an adverse impact on community character, all of these things that were already considered by the board when you had your original deliberations. So I don't believe that there's a legal basis on either 14 Aslan, 6 Marmon, 65 North Cole, or 59 North Cole for denying the revisiting of those variances. Obviously, we're conforming things to circumstances as they currently exist, and I don't think there are a lot of other options. Nonetheless, it's obviously important to these county agencies that there be reasons on the record, so we've prepared on each one of these the reasons on the record that would justify the decision that the board had already made. It's a strange procedural posture. I'm not the board's counsel. I think there would be a very, very, very high and probably insuperable bar to denying any of these that wouldn't leave the village exposed legally. But that's my point of view, and that's my client's point of view. How do you wish to proceed, Mr. Chairman, procedurally? We have these letters on each one of these applications, and we appreciate the opportunity, if in fact a supermajority would be available, to get this done with, insofar as this is really a huge bureaucratic pooper-scooper operation more than it is an evaluation of the substance, insofar as these buildings are already built and the board already approved the variances.
Okay, so I would ask our counsel for comments on this.
Well, have you, Mr. Carver put together his arguments, which he just verbally summarized. which you haven't seen yet, I don't know if you're comfortable just looking at it now and discussing it, or coming, taking it home and reviewing it. Is there one for each, or
Well, I would,
does
yeah.
this cover all four?
But no, we have a letter on each. We have a letter on each. We want them, I know you maintain separate records. The problem is that all these folks who now have these things approved years ago, people can't get sewer. Because in 2016, a package wasn't sent out for comment.
So the houses are built, they cannot move in. And that's what, that's status quo.
So what's the pleasure of the board?
So we have these reports on each one of these, which set forth reasons.
You're
that-
asking for my legal counsel? I'd like to give it an attorney-client confidential discussion, which is outside of the open meetings law. It's not an executive session, it's an attorney-client confidential.
How much time do you?
90 seconds?
90 seconds. Okay.
Thank you.
You need the motion to go on?
No. You have legal questions for me, and I
Okay.
recommend that I give you my
We'll take a
counsel.
3-minute break.
An attorney-client confidential.
Okay. Sorry.
Yeah, I can.
The problem is when you're looking for him to give sensible advice about an absurd situation. Who? All right, so there was no shame up 3 years ago. It wasn't done.
Not my problem.
No, I mean, it should have been done. But it wasn't done. Why am I doing that? Buildings built, permits, inspections, all this.
We did everything right.
I'm saying, but nobody wants to sue the county and say you don't have the right to impose this requirement on me. So we're going through all this.
Don't give them 911 anymore.
How long ago
Huh?
was it gonna take you to council?
Oh, you can reach an agreement.
No.
What
6 months.
You can reach an agreement with
6
them.
months.
Okay.
6 months, no water?
No, but this problem's been going on for a year and a half. All the uberchuchums, yeah. No, you're gonna see by the elections, it's all gonna change.
Right, because he ran away from the
Goodbye.
the county legislator.
Goodbye.
Where you going? Where you going? Moving to where? To Europe?
No, I'm saying, they can go sit there, they have a good time without me, so they're doing a great job.
Who's doing a good job?
Whoever's there,
Elon is not running.
whatever their name
Elon's not
is,
running anymore.
whatever their name is, they're doing a great job.
And they.
Everybody's doing a great job.
Hoy que hemos
Well, the problem is, what the county asking this board to do is not sensible. So, what kind of advice can you give about how you do something? There's no right way to do this, it's absurd. No, I'm saying, it's absurd.
Go retroactive on every application is, doesn't make sense.
Especially decisions made by
Ryan, how many of the homes are built?
That only works if you have,
3 are totally constructed and 1 is foundation and framed. Well, the problem is when they're going here, things you can't, that doesn't apply retroactively. You can't say, okay, I told everybody else before I got here is down there. That's not the way it works. You get to make policy for your term of office going forward. You can't.
I'm not a lawyer, but I go just like that.
Well, it's the same way as if someone comes in and starts revoking building permits in the middle of a project, it's illegal, you can't do that. You have authority to give the permit. The person is justified in relying on your authority. Unless you can put it totally complete, It's a valid governmental act. Even if the guy comes in after you,
Did you distribute all your correspondence, Ryan?
I distributed on one item, I
Distribute all of them.
all of them.
I don't have the name.
14 Aslan, this is 6 Norman.
14
Back on
Aslan.
record.
Oh, wait, let me get my.
What's the story on 14 Aslan? The foundation is bringing forth?
Which is the one that's halfway?
Okay, the meeting has
This one has a
reconvened.
foundation,
We
it's a
have,
framing.
But it has a window, 65
we
North
have
College.
completed our
65
attorney-client
North Pole.
confidential discussion.
65 North Pole
Back on the
has
record.
framing with the windows already in. There you go. 1 second. Let it not be said that we won't try to help you with your records.
So we have to do each one separately or do all four together?
No, I'm gonna just reference them in the record, we'll do all of them.
Okay.
You know, I appreciate, you know, it's your,
Seriously, much better.
2 hours left.
It's not done until it's done.
Imagine if government worked like that. You can never trust anything.
Don't push it. Another one? Go back to it.
Ryan, we need copies.
No, I don't. You need copies. Diana, copies.
Your friend was in the seat.
My friend? My friend? Which one is it? So here's 14 Aslan.
Which one?
You got it.
Okay, we're back on record.
All right,
You got everybody else.
I don't want
I
them
know
to-
your mother loves me.
he's still hanging out.
What else?
I'm ready, I'm ready. Okay, I've got them all. All right, so Mr. Carbon, representing the applicants, property owners for 14 Aslan Drive, 6 Marmon, 65 North Cole Avenue, and 59 North Cole Avenue, has, sorry,
I got everything. Yes, yes, perfect. Beautiful.
has submitted correspondence, all dated March 14, I'm sorry, no, one of them is dated March 13. 6 Marvin Place is dated March 13, 2018, and for 59 North Cole, 14 Aslan, and 65 North Cole, they're all dated March 14, 2018. And in that correspondence, Mr. Carbon delineates with more specificity what he has described verbally on the record, that all of these applications received final approvals by the Zoning Board of Appeals. Building permits were issued, construction commenced, and on 3 of the 4 homes, which of the 4 was not completely constructed?
65.
65 North Cole,
All right, so
that
six-
has foundation, framing with windows, I mean,
All right,
it's...
so
Well,
other than 65,
she's showing.
other than 65 North Cole, all 3 of the homes are completely constructed in accordance with the approved plans and drawings, correct, Mr. Booker?
My understanding, yes.
And all that remains really is probably final inspection and a CO.
Well, they can't get the CO unless they can get the water and sewer.
Yeah, they need that. They can't get one.
Understood. 65 North Cole Avenue, foundation poured, framed, and windows installed. And roof. And roof.
No water, no sewer.
Okay. And the reason that it's back before the zoning board of appeals is because back when these applications were approved by the zoning board of appeals, the then clerk / secretary to the zoning board of appeals did not send the application to the Rockland County Department of Planning as required under New York State General Municipal Law, Section 239-M, as in Mary. That was not,
Though all hearings were publicly noticed, published in the newspaper, all that kind of stuff, so.
the fault is not due to the applicant / applicants / property owners.
Right.
feel that the village here is really compelled to reapprove the application and to override the disapprovals of the county GML that have come, I guess, very recently. How many years later, or months later?
Just years, in all instances.
Several months later. However, based upon all the facts and circumstances and applicable law, I feel that the zoning board is really compelled at this point to reapprove your previous approvals and override the county GMLs as requested by the applicants and property owners' attorneys in the correspondence that I referenced in the record. That's my legal
Okay, is
counsel.
there a motion?
Motion to approve?
To reapprove.
To reapprove
With
to
the county, with the overrides of the county GML letters as described in Mr. Carvin's correspondence.
Okay, is there a second?
I second.
Okay, can the clerk call the roll?
Hello, yes, I will. Okay, ready?
I motion it, second it.
Okay, now we're gonna do a roll call vote, right?
Yep.
Okay.
And this is all from one,
All four.
set
All
of
four.
approval.
A through D.
Member Solomon,
Yes to approve?
Member Patrick. Yes to approve. Okay, Vice Chairman Fanny,
Just approve.
and Chairman Hopson.
Yes to approve, all passed.
Alibi. Second.
Okay, there's a second, all in favor, say aye.
Aye.
Thank you.
Good night.
God bless.
Thank you very much. Thank you.
Well,